How dare you?
Hey, good morning, good afternoon, good evening, good night, everybody. How are you doing? It's me, Illegal Vices, and we are here on a very dark and cold Korean Tuesday night. I hope everybody else is doing well. I'm doing great. It's been a good day. It's been a long day, but it's been a good day. I'm just glad we are all here, and we can sort of play catch up. We got some updates in the Maya Kowalski case, as well as we've got to go back a little bit and look at some of the exhibits. The exhibits I want to look at tonight are the affidavits filed by the defense in their motion to for a new trial due to jury misconduct, and the plaintiff's affidavits, the lawyers' affidavits, and witness affidavits that are attached to their response to that. So that's kind of what we're going to get into today here real quick. Looking over here, we got 272 people here lined up already. That's awesome. That is really, really amazing. Thanks for being here, everybody. Oh, I see. Oh, hey, Melanie, I saw me in Nick's chat last night. I didn't put up a like and subscribe poll. Let me do that real quick. I thought I did, but I guess I didn't. So every day here, if you're new, we do a little like and subscribe poll here, just to remind you to hit the like and subscribe button. Like, subscribe, and vote. How many zeros should the award have had? Question mark. None, in case you think that it was an unjust verdict, an unfair verdict. The right amount is the next choice. The right amount were given. Next option, 14 more zeros. And let's see, the last option, there's not enough zeros. Sorry about this. We're just doing a poll on the fly here. All right, we have our like and subscribe poll up today. If you have not subscribed, by the time we're done here today, or by the time you have to leave, I would hope that you would do me the honor, do me the privilege, and take a risk with me and give me a subscription there, so you can come back and see what else we do as we talk more about this and other cases and other matters. And hit the like button if you're here for a few seconds and you're not thoroughly appalled. I would hope that you would do me, again, the honor of giving me a little like. Just click that like and subscribe button. Take our like and subscribe poll. As we just said, the poll today is, how many zeros should the award have had? None. The right amount were given, 14 more zeros, and there were not enough zeros. Well, we do have some nuns. See, I like this. I don't like the streams where everybody in chat is all in agreement. It's a big echo chamber where essentially we're just preaching to the choir. I like to hear differing viewpoints. I like to hear the civil arguments in favor. If people are just going to call each other names and things like that, nothing is productive. But if people have well-reasoned, well thought out, and well-based reasons for why they think that a verdict didn't go the way they thought it should go, or the way or someone gets an award that they shouldn't have had, or that they should have had, or whatever. I like to hear those divergent viewpoints, because that keeps us on our toes. It keeps us thinking, and it keeps us from getting a little bit stale. And speaking of stale, starting us off with the $2 super chat, and let's give Mike. Let's give Marv White the honors of the first super chat of the day. Poll is still whited out for me. That is right. Apparently, there's some big problem that YouTube has with their update that whites the polls out for a lot of Android users and others as well. So it's totally up to YouTube and for them to unintercourse themselves and get things back the way it should be going. So, but thank you so much for pointing that out, and let's sit back and enjoy what's going on here today, if we can. Because what we've gone through is we've gone through the defense and the plaintiff's motions and response for the new trial due to juror misconduct, as well as the motion for a new trial based on based on judicial error, based on an improper award, et cetera, et cetera. We went through last week. Now what I want to do is go into the affidavits that are supporting those individual motions. There's a few things there. There's a motion from there's an affidavit submitted by the defense lawyers, and then there's an affidavit submitted by I keep wanting to say prosecutor, by the plaintiffs, and then there's also a couple of witnesses from the plaintiff's lawyer's office. And before we do that, there's a couple of updates we want to bring. So let's do that. We'll keep things monitored here, and we'll get the super chats. If there's a lot of them, then we'll get them in batches, so we don't have to keep interrupting. If there aren't, we'll just address them as they come in. Not required to engage, but graciously and humbly accepted if anyone throws any in. With that, let's get on with the main part of the day. Glad to see all of you here in chat. There's some very familiar names, and the mods are doing their great moddy job. And there's some new faces here as well. So thank you very much, new people, for popping in and giving me a listen. Because I haven't seen any of the other people that are doing. Of course, I haven't watched them all, but I haven't seen any of them that I have watched or have seen that have addressed these affidavits that are attached as attachments to the main motions and other submissions. Oh, good morning, everybody. So good to see you all here. Thank you for all the good wishes and morning stuff that's going on. Again, if you're new here, I have like a 50-pound, 23-kilogram English bulldog snoring right here on the floor next to me, and there's another one in the other room that might come in and join in the snore fest. So all the snores, grunts, and heavy breathing you hear is not mine. It is, in fact, the sleeping dogs. Strawberry and Yoda are my dogs. All right. To start out with, let's have a couple of updates. There are a couple of updates that we need to do here. And where have I put there it is. Well, that's not the right thing to do. No. Let's try this one. Where has it gone? Oh, this is lovely. Hang on just a quick second. We need to outsmart. There we go. Got it. The present and share screen button was being a bit wonky, but we have unwonked it, and there we go. This is the first order. This is illegal. I like this. It's an order requesting someone to do something. Usually requests are requests and orders are orders. So this is an order requesting plaintiffs to respond. Now you'll remember that they had the largest motion. It was 144 pages submitted by the defense lawyers a while ago. It was the defendant's renewed motion for a directed verdict, which again is the defense basically saying, all right, we know there was a little bit of evidence to support what the plaintiffs had to say, but it was clearly overshadowed by the main way. And it was so wrong that, Judge, you just need to throw out the verdict and just give us the win on all accounts. There doesn't need to be another retrial. There doesn't need to be any more hearings. Just you know that they shouldn't have won, so just give it to us. That was the renewed motion for directed verdict, the motion for a new trial based on judicial error and improper calculation and assessment of damages, and the motion for remittiture, which is a motion that's essentially to reduce the damages. This is, Judge, if everything else fails, if you don't want to give us a new directed verdict, if you don't want to give us a new trial because of judicial error, if you don't want to give us a new trial because of the improper assessment of damages, then please just at least step in and you just reduce the damages to whatever you think are fair. And they gave some really lowball figures. So what we've got here is this, that was 144 pages, or 144, 146 pages, something like that. This is the judge's order requesting the plaintiffs to respond. On or before 4 p.m. on Monday, December 11th, 2023, plaintiffs are requested to file a response to defendant's renewed motion for directed verdict, motion for new trial, and motion for remittiture, done and ordered in Sarasota, Guyana, Florida, on December 1, 2023, by Circuit Judge Hunter W. Carroll. Okay, so the plaintiffs have until Monday, December 11th at 4 p.m. to file their answer, to file their response to these motions. And Hippo Lover, hey, good to see you here. Hippo Lover, the $2 super chat. There's also a new motion with the agenda on the 15th. Yeah, we're getting there. That's the next little update we have. Thank you so much. Thank you so much for being here. It's a pleasure to have you here. And Uncivil Law, hey, how are you doing? Can my response just be saying it's stupid and a waste of my time? Is that professional? Well, I think that's kind of sort of if we were to summarize the plaintiff's, what was it, 26-page response? That's kind of what it was. So it's similar there. And that's the certificate of service. And there's everybody that received service of it. So that's that little update there. And our next update, let's see. Oh, where's our next update? No, we don't want to. Why does it think that I want to save any? No, I don't want to save anything. All right, let's in big in this one here. This is the amended order setting a hearing date. This is our next little bit of an update in the Jack Kowalski. Jack Kowalski, as parent and next friend of MKA minor, Jack Kowalski, a personal representative of the estate of Beata Kowalski, plaintiff versus Johns Hopkins All Children's Hospital, Inc. The amended order setting a hearing. And it's amended because they had apparently had improper Zoom information during the first hearing notice. So they have to amend it and give them the right information so that nobody can come back later and go, yeah, you didn't do this right. So please know the hearing is scheduled for North County, not South County. So apparently in the first order setting the hearing, they said it would be in South County. So Courtroom 6C, you are notified that a court hearing is scheduled in this case before the Honorable Hunter W. Carroll as follows. Date and time, December 15th, 2023 at 8:30 a.m. So it's going to be it's going to be an early morning trial. I don't know if it's going to be streamed live anywhere. We'll just have to see, but it will be on Zoom, and who knows what will happen from that point. But it's only, the time reserved is only half a day. So the judge isn't expecting this to go past lunch, and there's a lot that they're going to be discussing. So I'm sure that doesn't telegraph what the judge is thinking about the motions, but he's limited quite a bit the amount of time that he's going to give both sides to argue their motions and responses to the motions. So here's everything they're going to discuss in the morning of December 15th. Plaintiff's motion for entry of final judgment. And that's just basically, let's just finalize this right now and stop screwing around with everything else. Just dismiss everything else. I haven't seen it, I haven't read it, but I'm pretty sure that's what the gist of it is. Just get rid of everything and just finalize this thing now. Defendant's motion for new trial based on juror misconduct. So that motion, they're going to be arguing that as well as the supplemental defendant's motion for new trial based on jury misconduct. That was the really, really stupid, ugly, bad, and I think highly unprofessional one that dealt with allegations that had happened 20 years ago that were never followed through on and never prosecuted. And so, yeah. And also the defendant J. Hatch's renewed motion for directed verdict, motion for new trial, and motion for remediator. Again, that was the 144, 146 page thing that was filed a little bit ago. Matters associated with liens. Apparently liens are starting to come into these things. Matters associated with pending sanctions motions. They're going to be talking about the sanctions that have been asked for. And a case management conference. It's not an evidentiary hearing. So it's and here's the agenda. Here's the agenda for this hearing. This tells you a little bit about what's going on, the time that's going to be allotted to each of the parties for their arguments and whatnot. During the December 15th, 2023 hearing, the court anticipates that it will call the following topics in the following order. The court does not anticipate ruling from the bench and likely will take all matters under advisement for later disposition. So don't hold your breath for the judge to make any decisions at the trial on December 15th, at the hearing on December 15th. He'll listen to the arguments, take his notes, do things, and then he'll consider them, then issue the orders at a later date, issue his decisions at a later date. The court is aware of how it rules on certain motions may moot other motions. So if he decides to declare a new trial or whatever, some of the other things he doesn't have to rule on those, and vice versa. So let's see here. The court is aware of The court is aware that how it rules on certain motions may moot other motions. However, all motions will be argued during the December 15th, 2023 hearings, and the parties shall be prepared accordingly. So come prepared to argue everything. All these things that everybody has dumped in the court's lap, come and be ready to argue them. And be concise, because you don't have a lot of time. The topic of alleged juror misconduct. Whether the court will allow juror interview, because remember, for the alleged misconduct of juror number one in that ridiculous motion, and the highly ridiculous and I think very unprofessional and maybe borderline unethical supplement to that because of all of these things that Mrs. Juror number one did, juror number one was somehow tainted, and there was somehow impropriety, and it just didn't make any sense. It was all it was dumb. As Kurt just said here a minute ago, it's sort of like a toxic waste dump. It's bad. Yeah, it should have contained a Prop 65 warning because it's toxic and could cause cancer. Yeah, it's not a good motion. So the court's going to decide whether to allow a juror interview, because they want to interview the jury, the juror member, and possibly Mrs. Juror number one. And why do they want to interview them? Because there's all these perceived possible, it's possible that this happened at this point. It's possible that maybe someone considered at one point the suggestion that it might be okay to do something else. So what they want to do is they want to get juror number one and possibly Mrs. Juror number one into a room and essentially interrogate them and go on a fishing expedition to see if they can find some additional evidence against to support their theory, their unsupported and so far wholly unsubstantiated theory that juror number one did anything wrong. They want to go and do this fishing expedition. So they want to pull in for an interview. They want to do discovery, which could mean going through computer records, going through phone records, etc., to try to dig up some information to support their wild allegations, or both, and if so, the parameters and timing. This will be a non-evidentiary hearing. No evidence will be taken. A total of 20 minutes per side, for a total of 40 minutes. They're giving they're giving both sides 20 minutes, which for me is pretty. I think it's a short time for the defense, because with the stuff they laid out in that brief that motion of theirs, they're gonna need a lot more than 20 minutes to connect all of the 3x5 cards and various colored yarns together to somehow try to justify their motion. But the defense, the prosecution, dang it, I'm going to have to stop saying that. Anytime I hear just a P word, I think prosecution. Every time, the plaintiff, I don't think is going to need 20 minutes. The plaintiffs, I'm sure they're going to take it, but their argument can just sort of be...
everything that guy just says is bullshit. Thank you.
And that's kind of all they're going to need for that first one, I think. Some variation on that theme. They'll probably take about 20 minutes to say it, and they probably won't use any of the cursey words, but it'll sort of be the same thing, I think. And then for the topic of a renewed motion for a new trial, I think that should be directed verdict. I think it should be the topic of renewed motion for a directed verdict. But anyway, a total of 15 minutes per side will be given, and for a total of 30 minutes. All right. Fair enough. Topic of motion for a new trial, exclusive of juror issues. So this would be for judicial errors, for mistakes that the judge allegedly made. A total of 15 minutes per side for a total of 30 minutes. And a topic for remittiture. Again, that's the reduction of the damage. This is the judge just sort of going out on his own and saying, all right, I know what they awarded, but this would be a more proper award, so I'm going to reduce the award down to this particular amount. And then next, on topic number 5, will be a topic for a motion for entry of final judgment, total of 15 minutes per side, total of 30 minutes. This includes discussion of the application of the lien, whether any insurance company needs to be added to a judgment, should a judgment be entered, and accrual of prejudgment interest, if any, should a judgment be entered. And number 6, sanctions motions. This is what I want to see. I want to see the sanction motions, because that, and I notice he's limited each side to 10 minutes on that argument. I think this is going to be one of the most contentious ones. This is where the lawyers are fighting for their own money. and they're not going to be happy. A discussion of whether and under what conditions the court will address pending sanction motions. So they're not going to actually get into the sanction arguments. They're going to get into the groundwork for discussing the sanctions motions, and a case management conference, which is just anything else. That's the collective, the gather all thing. Any other matters that are provided in the rules. Now, Judge Carroll has a hybrid courtroom, which will allow participants to appear either in person or via Zoom. Please do not call the judicial assistant. There's the Zoom credentials. There are no fees for attending, blah, blah, blah. Expectations for all participants attending Zoom hearings. The court reporters, digital court reporting, no recording proceedings. By court rule and court order, you are not authorized to make your own audio or visual recording of the court proceedings. No one may take screenshots or other audio-visual depictions of court recordings. Recording a court proceeding is strictly prohibited unless approved by the judge. If you violate these rules, you may be held in contempt of court. Members of the media must comply, blah, blah, blah. Well, seeing how I don't live there, I don't care. Interpreters, we don't need any interpreters done and ordered. Basic boilerplate stuff there at the end. We do not need to do that. All right, before we move on to the next section here, let's make sure we get all of our little super chatty stuff out of the way here. We've got a couple, so we'll do these two. T-Rex Trucking and More. Good to see you again. Thank you so much for your generous super chat. You said John dropped kids all prisoners hospital wrong. Yes, I did. I apologize. I made a mistake and said John dropped kids all prisoners hospital incorrectly. I said Johns Hopkins all children's hospital. I'm sorry. That's my bad. And €2. Thank you so much, Mathis Grease. We need to interview Carol from HR and Pepe Sylvia. Thank you. Thank you so much for that. We're well on AMG. What's MG Laws here as well? Thank you. Hey, what's up? Oh my gosh, we got to get into the meat and bones of this now. The meat and bones of this that we're waiting for is the affidavit of Ethan R. Shapiro. It echoes a lot of what was in their motion. So there's a lot of duplicative ground here where it's been discussed previously in their motion to support the new trial based on juror misconduct and interviews and discovery, etc. Then after that, we're going to get into the plaintiff's response. The plaintiff's response to that. And that's where we need to go today. We'll see. I don't know. I'm not sure how long it will take us to get through these, but we will do it. And again, bear with us here as we get through some of the, a lot of this is duplicated, it's the affidavit in support of their motion. So it's going to say a lot of the stuff that's there. Amber C says, do you think the time limits give any indication as to what the judge is feeling with all this crap? No, I don't think so. No, I don't think so. Because the judge hasn't heard the arguments yet. I'm sure he's got some personal ideas, but he's still got to weigh the evidence, still got to weigh the arguments. And you look at all the legal reasoning and all the support. I think he just wants them to be concise and short and not waste a lot of time. If you have something to say and you can't say it in 10, 20, or 30 minutes, you probably don't need to be saying it. So here we go. Let's get into the oldie affidavit here. This is, of course, prepared by Ethan R. Shapiro, Esquire. I just have this thing. I think Esquire is so. For someone to put Esquire for their own name, I think is just, I don't know. It's weird. I would never call myself Esquire. Andrew Esquire, on the other hand, that's kind of his YouTube handle name. So, but yeah. Comes now Ethan R. Shapiro, Esquire, and deposes and says, I am over the age of 18, and 18 in numerals in case you have problems on reading the word 18, and I'm completely competent to testify to the. Okay, I'll just let that. I'll let that unsupported that statement which is completely unsupported by evidence. I am competent to testify to the matters contained within this affidavit. I have personal knowledge of the facts described in this affidavit, or personal knowledge based upon personal inquiry, consultation, and research. I am authorized by Johns Hopkins All Children's Hospital to make this affidavit. I incorporate by reference Exhibit B to the above reference. And he refers to all of these motions, which were, I mean, all of these exhibits and all these pages of exhibits, which we're just not going to be able to get to. Flux says, do the gay Shapiro voice, Jeff. I don't know. I can't do it. Macon does it so much better than me. I'm kind of congested too. So I just sort of sound like a wheezing old man today. Apologies for that. Right. Incorporate by reference Exhibit B to the above reference motion, which supports the factual allegations made herein regarding juror misconduct. Exhibit B was prepared by Johns Hopkins All Children's Hospital, based on the firsthand research by counsel. And again, the names are out there. We're just going to do the L's. Mr. L served as juror number 1 and was the foreman of the jury this time during the trial. Mr. L, here and after juror number 1, was apparently married to Mrs. L. Well, there's a hell of a bold statement, isn't it? Mr. L was apparently married to Mrs. L. That's why you pay these lawyers big bucks, people. That's why you pay them big bucks. He won't even concede that point. They won't concede anything. Just apparently. I hate these guys a lot. Throughout the trial, Mrs. L heavily and consistently engaged in public commentary on this case through her YouTube username. Over the course of several weeks during the trial, Mrs. L posted at least 81 known comments to YouTube channels streaming this trial. See, you people over there? You people there in chat? She posted 81 known comments. For most of you, those are amateur numbers, aren't they? So... 81 known comments to YouTube channels streaming this trial, such as Recovery Addict, Law and Lumber, and Lawyer You Know. Alas, I didn't stream anything, so I don't even get an honorable mention. Thank you. I don't want to hear anything. This is one of these times where I'm really happy I didn't cover something because I don't want my name in any of these documents. Her comments largely consisted of sharing her opinions. Oh, sweet baby Jesus. Good thing we aren't allowed to do that under the Constitution, First Amendment. Her comments largely consisted of her sharing her opinions. This woman who's married to a man was sharing her opinions, which were biased in favor of the plaintiffs. And again, I get the feeling, and from my read through, I wasn't really thinking of the mindset of how I'm going to present this when I go through it. But now I'm kind of feeling that we're going to do a lot of what we did during the reading of the actual motion for all of this BS, which was kind of end every sentence with a "so" or a rant about how she was under no orders and was not actually a juror in this case. So I'm kind of thinking that's where we're going to be going down that. Yes, some Vice Squad members can't comment that much in one stream. Yeah, those are amateur numbers. And let's go, Brandon. Should have been shit posting instead of opining. All right. Well, anyway, her comments largely consisted of sharing her opinions, which were biased in favor of the plaintiffs. In addition, she shared information about the case that could only have been obtained through direct communication with juror number 1. And when we went through the motion, we hit every one of those allegations, and we all pretty much came up with, that's a crock of shit, because we all had exactly the same thoughts, and I didn't know I theoretically knew there was a juror number 1, but I didn't know anything about juror number 1, and I certainly didn't know if it was a male or a female, and I certainly didn't know if they were married or who their spouse was, but we all came to the same we all came to the same opinions, the same questions, the same everything. We debunked all of those stupid claims that they could only have been obtained through direct communication with juror number 1. So we'll hit those again as we go through this stupid motion. I mean, this stupid affidavit attached to the stupid motion. For example, during the live stream coverage of Detective Stephanie Graham's cross-examination on October 20th, 2023, Mrs. L posted the following comment: "The juror Leo will be asking questions." Again, that is the stupidest thing. That is absolutely the stupidest thing. A cop on the jury. Is there anyone that supports the plaintiff or the defense that had any question in their mind that a cop on the jury would be asking another cop questions. We all called that one. Everybody I've seen called that one. Said, "Oh, he's going to have there's going to be questions." It would be surprising if he didn't have questions for the witness. The day prior, Mrs. L posted to that same YouTube channel, Detective Grant, Leo juror, lol. So what? She is completely and absolutely free to do that. We've already established that a bajillion times. Free to do it. She's not under any order not to say things like that. And that is just, okay, so, boy, during the first YNW Melly trial, we said, ooh, undercover detective, lol. Okay, so dumb. Notably, Mrs. L sought out and developed a relationship with Jules. Show me a single piece of evidence. Show me a single piece of evidence that anyone has seen to date that says that Mrs. L, juror number one's wife, sought out and actively developed a relationship with Jules. None of us know what that means. Here it says, I still don't know what Detective Grant Leo juror lol means. I don't think any of us do. Yes. Jeez. Show me any evidence that shows that Mrs. L actively sought her out and actively developed a relationship. Or did they just happen to meet up in court and talk a little? Who knows? And again, it doesn't matter. Who served as plaintiff's online public advocate. Did she really? Have you seen the online public advocacy contract? Have you seen any instructions from the defense, from the plaintiffs asking her to do this or instructing her to post these things? Have you seen any of these things? I haven't. They exchanged messages online. Oh no. Personal phone numbers and made plans to meet and can be seen speaking to one another. Oh, I hated the motion. And I just kind of breezed through this, reading this affidavit. I've already decided on page 3 of 21 that I hate this affidavit more than I hate the motion, if that's possible. I hate this even more. I don't know why. It's striking me as something a little more annoying than the motion. They exchanged messages online. Personal phone numbers, made plans to meet and be seen speaking to one another while Ms. L physically, she physically attended the trial. Okay, I like this wording better. Mrs. L physically attended the trial on October 30th, 2023. In the actual motion, it was Ms. L physically appeared in trials, as if she was some sort of apparition or ghost that just physically manifested within the walls of the courtroom. So yeah, so I give him kudos for improving the wording from physically appeared to physically attended the trial on October 30th, 2023. Notice how he's like, the apparition of Mrs. L physically appeared, physically manifested in the court the day before Halloween, where Mrs. L's husband was impaneled as a juror. So guess what? Every single person in America has a right to go and sit in that trial. Being upset or shocked or horrified or unbelieving that a wife just might go and sit in a courtroom to look at her husband all day is a shocking, horrible thing. Both Mrs. L and juror number 1 knew one another were present in the courtroom that day. I knew that the plaintiff's lawyers and the defendant's lawyers were in court every day. So effing what? Mrs. L's relationship with Jules is most unsettling because of Jules' close involvement with the Kowalski family. Why is it unsettling? Jules communicated regularly with the plaintiffs Details shared publicly on her TikTok account. On October 9th, 2023, Jules shared a TikTok that she gave Maya Kowalski her rosary beads that she had during her live testimony that day. On October 11th, 2023, Jules would again share this story on the Recovery Addict YouTube channel covering the trial, stating that she texted with Maya Kowalski over the weekend, gave the rosary to her and Jack Kowalski for their testimonies, and asked plaintiff's counsel not to object to the jury's question regarding her carrying a rosary because Maya had the rosary in her pocket. All right, so let's again go back to this and break out your 3x5 cards, break out your little index cards, grab your various colored string and yarn and some thumbtacks and maybe a little bit of scotch tape if that's what you're into. They're arguing that we need a new trial because some lady named Jules met a juror's wife in court. But what is even more shocking than that is that they need a new trial based on juror number one's misconduct because Jules made friends with the Kowalski family. Jules contacted the plaintiff's lawyers. Maybe, I don't know. It says maybe. Because Jules gave Maya her rosary. Jules told the story about giving Maya Kowalski the rosary on the Recovery Addict channel. Jules talked to Maya Kowalski over the weekend. Anywhere in that description, did you hear anything about juror number one's wife? Let alone did you hear anything about juror number one himself? So we've got them as basis to set aside this verdict and have a new trial based on alleged juror misconduct that someone who has nothing to do with anything talks to the family and gives them a rosary and tells a story about it. So somehow that's imputed to juror number one's wife, which is somehow in turn imputed to juror number one. That you figured out. You do the logic on that one. I need, like, Quick Bites keeps saying I keep failing to press the how dare you button. The how dare you button doesn't really describe. I just need like some sort of dumbass button, or I don't know. Anyway, so yeah, that's one of the reasons why they think they need a new trial, because someone in the gallery made friends with the family and gave them a rosary and told them not to object about it because she didn't want to make a big deal about it, apparently. Okay, so how does all of this tie into juror number one's misconduct? This demonstrates that Jules was more than just an innocent bystander. So what if she is? But an advocate for the plaintiffs at trial. How could she be as... I'm exasperated already. This demonstrates that Jules was more than just an innocent bystander, but an advocate for the plaintiffs at trial, and on several social media platforms, bringing trial-related content to thousands of viewers each day, just like every goddamn news station in Florida and most of the United States and parts of the world, just like everybody on Law and Crime, just like everybody on Court TV, just like everybody everywhere. Bringing trial information every day on social media platforms everywhere to not just thousands, but they do it to millions of viewers a day. Law and Crime, Court TV, millions of viewers a day. Jules, who gives a flying F that Jules took several pictures with plaintiff's witnesses and trial team during the trial? I think we need to throw out the Johnny Depp trial because Ben Shue took picture with a llama. Camille Vasquez took pictures with a llama outside the courtroom. People took pictures with them. So effing what? That's what people do. They take pictures of lawyers in famous cases. Good thing she didn't get their autograph. Well, maybe she did. I don't know. So again, totally irrelevant and stupid information. Jules took several pictures with the plaintiff's witnesses and trial team during the trial and can be seen in the center frame. that's a good place for whoever is asking for the picture to be taken. They usually want to be centered, like front and center of a photograph of the plaintiffs and their counsel following the verdict. Following the verdict, not that it matters in the first place anyway, but following the verdict makes it, even if it's possible to be less relevant, following the verdict does make it less relevant. I'm just arguing it's completely irrelevant, so it's not possible to be less relevant. But if it were theoretically in some quantum universe possible to be less relevant, then it would be less relevant because it was after the verdict. On November 6th, 2023, and again, this is a lawyer. This is one of the lawyers in the case giving a personal sworn affidavit under oath and penalty of perjury and all those other fun things you do when you sign an affidavit. This is his actual sworn statement that he knows these things happen. I think this is a very, not only unprofessional, but it might possibly be slightly a little bit dangerous for him. We'll see. On November 6, 2023, the court heard defendant's motion to disqualify juror number 1, which was premised on juror number 1's suspected. What was that word again? Suspected bias, not premised on juror number 1's actual bias and prejudice in favor of the plaintiff. The suspected, even when they made the motion, it was suspected, not, or should we even say alleged? Who suspected it? The people that made the allegations. So let's just say alleged bias. They had no proof of it, which is kind of why the judge said, he gave a big long speech about how he thought everything was done well. He thought he was being attentive. He thought he was asking appropriate questions, et cetera, and he denied the motion. So it's suspected bias in favor of the plaintiffs. While plaintiff's counsel Greg Anderson initially agreed to substitute juror number 1, he's like, okay, I mean, the rationale for that, and I wouldn't want to put words in Greg Anderson's mouth, but it could be like, all right, whatever, we've got backups. That's why we have alternates. You want this guy out? We'll put somebody in. We got people to burn through. Mr. Anderson changed his position after consulting with Mr. Kowalski, stating that his client feels more comfortable with juror number 1. That is just a very, very slight, major distortion of what was actually said. What was actually said is he was on board with it. He was good with making the change. And then he said, oh, wait a minute. We've been talking about this for 15 minutes, but I haven't done the one thing that a good lawyer should and probably must do, which is to ask their client what their client thinks. And there is nothing wrong with that. In fact, that should have probably been done at the beginning of the discussion rather than when he thought, oh my God, I forgot to ask the client about this. So he goes back and he talks to his client. His client's like, I think I like juror number 1. Let's keep him around, which is his right to say that. And it is also the plaintiff's lawyer's right to go and say, hey, this is what my client wants. He wants juror number 1. And then, even after hearing all of this, the court can still say, I don't care what your client wants, Mr. Anderson. We're still getting rid of the jury. We're still getting rid of the juror. They could have done that, but they didn't. At the end of hearing all of this, the judge, he just kind of chucked. Wow, what are you doing, Yoda? Yoda's pushing a chair around. Mr. Anderson changed his position after consulting with Mr. Kowalski, saying his client feels more comfortable with juror number 1. After the court denied the motion, Mr. Kowalski can be seen turning to Jules, who was sitting behind him and nodding his head with a smile. Now, this has been debunked by Mr. Anderson himself on Megan Fox's channel when he was on there. And Jules also said, I haven't gone back and watched it, but Jules has also said she was looking down when that happened, and he was looking back at somebody else. I can't remember who he was supposed to have been looking back at, but he glanced back at someone. But Jules wasn't even paying attention, according to Jules, and apparently from what people were saying, it doesn't show that on the actual trial either, on the actual video. So I don't want to say it's what it is, but again, this is a sworn statement under oath. We are walking slowly towards a line of possible perjury. Submitting a sworn statement with someone that he knows to be false. I would assume that they watched the video. So before they wrote this down. Right. So anyway, this inferentially demonstrates that the relationship between Mrs. L and Jules was far more involved than just an innocent friendship. Okay, let's say, just arguendo, as we say in the legal field, for the sake of argument, let's just say for the sake of argument that Mr. Kowalski did look back and nod and smile at Jules. So what? So effing what? We're 47 minutes into this and I haven't dropped an F-bomb yet. I can feel at least one brewing in the back of my skull. So, well, hopefully that won't happen. I'm trying to keep my cool here a little bit, but as I said, for some reason, I'm finding this more annoying than the first motion was. Let's put me down here a little bit more. I think just kind of see if we can give a little bit more real estate here to make it even larger. All right, just looking down and I'm thinking it's a little bit. There we go. All right. I think I'm covering some of it though. All right, folksy. So there we are. The Jules was far more involved than just an innocent friendship. I keep freezing? Am I freezing? Is there anybody that I'm not freezing for? Because I'm not freezing for myself. At least I don't think I am. Okay, not freezing for me. Okay, it's a some of you problem. It's not a me thing and it's not a most other people thing. So, all right, there we go. If it's freezing, then just refresh and it should unsort itself, or get a better Wi-Fi connection. All right. It also, not only does him be, again, this is just assuming this is all true, that when juror number 1 was retained and the motion to dismiss him was denied, that Mr. Kowalski turned back to Jules and nodded and smiled, which means somehow she had an inappropriate relationship with juror number 1's wife, who in turn would have had to have talked to him because they live together and they're allegedly and possibly married. The mental gymnastics that have to be gone through to get to the defense's conclusion, it is just exasperating. I don't have a better word for it than just exasperating. So not only was she allegedly more than just an innocent friendship with the family, it establishes a reasonable belief that the information relayed by Mrs. L to Jules about her husband's seat on the jury was also relayed to Mr. Kowalski, a party to the trial. That's just an utter sack of bullshit. Where is anything to even come remotely close to suggesting that actually happened? I mean, that to me is a ridiculous statement. On October 31, Halloween 2023, the day after attending the trial with Jules, Mrs. L posted a comment regarding the jury's thoughts and opinions on Catherine Beatty. And the defense's witness presented this the day prior, stating they did not like her. They did not like any of them. Obviously, the operative word here is obviously. Obviously, Mrs. L's information regarding what the jury, did not like could only have come from juror number 1 himself. Again, this is an utterly ridiculous assertion, because literally every person that heard Kathy Beatty testify. We didn't see the jury. We couldn't see the jury. We have no idea how they're reacting. Literally every person who saw her testimony said, holy shit, the jury is not going to like that. Nobody liked Beatty. Nobody. I think even the defense didn't like her. I think even they wish they hadn't had to put her on. I mean, that is one of the most ludicrous things in this entire brief is that only that is obvious. It's clear. There's no reasonable doubt whatsoever. It's just clear and obvious that the only way she could have known that nobody liked Catherine Beatty's, the jury didn't like Catherine Beatty's testimony was because juror number one said that. That is just patently stupid. Again, literally every one of us that saw that, every single one of us that saw that knew that. We didn't have to have Mrs. L tell us that. We didn't have to have anybody. We certainly don't need Shapiro to tell us that. Dumbasses. Similarly, during the second day of jury deliberations on November, oh, for fuck's sake. Oh, there you go. All right. How long did that last? I lasted 52 minutes without an F-bomb. Dang it. That one just kind of slipped out. The jury problem, the jury deliberation problem. Similarly, during the second day of jury deliberations on November 8th, 2023, Mrs. L paid money to Super Chat her comment regarding juror number one's frustrations with not being able to obtain the report by Christy Kirby, stating, "I think the note yesterday was frustrated jury that cannot reach dollar agreement and it will take days." Duh. When you have a 9-week trial and you hear the likes of Smith, you hear the likes of Beatty, you hear all of these other things that occurred and happened and went on during this trial to this young girl. When you hear all of that for 9 weeks and the jury walks into a room and an hour later they come back and we got a question. Can we see all that math stuff again? If you don't know at that point that they've reached a verdict and they're just trying to figure out how to calculate damages, if you don't know that at that point, you ain't as bright as you probably should be. Everybody knew that. Not only has Mrs. L paid money to Super Chat that comment regarding juror number one's frustrations, but was it juror number one asked for the information? Asked for the information, but was it his frustrations? Was he frustrated, or was the entire jury frustrated? My favorite one was the was the give us this shit text, or we need this shit, or we can't find this shit, whatever the shit question was. That was my favorite question. But literally everybody, and I think if you go, it would. I'm not sure if it was Megan or if it was Law and Lumber, but I think it was Megan. My Super Chat is on there going something along the lines, because I think I gave a Super Chat saying, "Oh yeah, they're done. They just need to know how many zeros," or something like that. Because it's okay. I am just absolutely flogging a dead horse here. I said, after 9 weeks of hearing this stuff, when they go in and they come out an hour later and go, we need to talk money. Where's the money stuff? Everybody knows they've already, even the defense knew that. Look at their faces when the jury asked that question. That was some funny shit. When they asked that question, you could see they were, every single last one of them, dead inside. They knew they had lost. I'm pretty sure they had figured out a long time ago that they had lost the case, but I think they were conclusively aware that they had lost the case at that point. Scrotium Bookerball says that was on Megan. Okay, yeah, all right. Yeah, so again, it clearly she doesn't need to talk to her husband to know that that's what was happening. All right, I need a palate cleanser. I need a palate cleanser there. All right, let's go through some of the Super Chats and the flagged comments that I have here. The DCV Titan, thank you so much. Well, my head kind of hurts today. I'm not going to do the big foghorn. We'll do a big collective ship's bell for everybody. The DCV Titan, thank you so much for the Super Chat. Was it biased in favor of the plaintiff, or did the plaintiff argue a better case and gain the favor of the public? Sounds like defense skills issues. Yeah. I can't argue with you there. And Kevin Collins, thank you for the $5. Thank you. Was that attached to a sticker? Nope, that was just a $5. Thank you so much. And Marv White, no feeling for me. You are taking lawyer pauses. No filler words when you're thinking. I do use a lot of filler words, but sometimes I'm just so flabbergasted that even my ums, ers, us, and ahs don't find their way into the sentence. That's kind of how it is here. Sometimes it's just like getting rabbit punched in the back of the head. You get kind of dazed and stunned for a little bit, and it takes your brain a while to start revolving again. Squid pro quo. Try that again. Squid pro quo. Do you think the defense actually believes their own bullshit? They had better goddamn well believe it, and I'll tell you why. I'll tell you why they better believe this bullshit. Okay, we're on page 5 here. If I forget, or somebody remind me. They need to do it. They need to believe this bullshit wholeheartedly, because we have a sworn statement here. The undersigned personally appeared, Ethan R. Shapiro, who verifies and affirms this sworn affidavit, and the same are true and correct to the best of his knowledge and belief. He has sworn that everything in this statement is true to the best of his knowledge and belief. So he better goddamn well believe every single literal word of this. So yeah, to answer your question, he better believe it. MG Law makes a good point. If I'm a judge, I'm entering a show cause order for the defense to provide some actual evidence for this, or I'm sanctioning the shit out of them and making a referral to the bar for discipline. That's why I'm saying they're walking very, very slowly towards that conclusion. And I mean, the chances of an actual perjury charge are pretty damn slim, but sanctions are not so far away. They're not too far away from those. And let's go, Brandon. Thank you so much for the super chat. I'm from Istid. There is a legal document meant up on this channel. God damn it, Jeff. There is a time and place for everything. Let's go, Brandon. For the first time, I have no idea what you're talking about. I'm from Istid. There's a legal document meant up on this channel. God damn it, Jeff. There's a time and a place for everything. All right. All righty. I got you. I got your back. Thank you so much. Let's go, Brandon, for that insightful super chat. Love you, brother. Marv White again. Feeling equals freezing. Oh, maybe y'all thought I was freezing when I was just like stunned silent for a few seconds. All right, let's get back into this, because we got a long, hard road to cover here while we get through this. As again, the defense's replying affidavit the prosecution did it again. 2 out of 3 ain't bad. The plaintiff's lawyer's response affidavit is much, much shorter. I understood the goddamn it. Yeah, me too. Well, we're at exactly the 1 hour mark. So let's do a little quick thing here for just about 30 seconds or 1 minute. We currently have about 1,000 people in here and 448 likes. But half of you haven't hit the like button. I would say if you've been here for more than about 20 seconds, you clearly like it to some degree. I hope you like it enough just to reach in there and click that like button while we're doing this. And if you haven't subscribed to me, please take a chance, take a risk, take a dare. Make a move and hit that subscribe button, and let's continue to do this in the future on other streams about this and other trials that come down. For instance, we're doing the YNW Melly murder retrial, and we got some Murdoch news coming up eventually, pretty here in the near future. And take our like and subscribe poll. Today's poll is: how many zeros should the award have had? 7% of you, nearly 1 in 10 of you, the 533 people that have taken the poll, nearly 10% of you have said that she shouldn't have gotten anything. Interesting. That's a pretty high number. And again, I'm glad to have dissenters and people with differing opinions here. So 7% of you say she should have gotten 0 zeros. 16% of you said said 14 more zeros. 31% of you said the right amount of zeros were given. And 46% of you say there are not enough zeros. And we'll let you to determine whether that means there's not enough zeros in the award or there's just not enough zeros in the universe to award in the award. So there we go. That's it. Just hit the like, hit the subscribe. We got 484 now. And let's jump right back into this. All right. Similarly, during the second day of jury deliberations, that's the one we just read. Other comments made by Mrs. L during the trial include comments regarding research of the case and monitoring the court's document. So effing what? Everybody, I mean, not everybody. I almost sounded like the defense lawyers there, using hyperbole and exaggeration to make a point. Lots of people researched the case. Lots of people monitored the court docket. I tried to monitor the court docket, but I couldn't find it because it's a weird site. And Megan, medium smart journalist Megan Fox, she had to do the stuff for me. But now I know where it is. Now I know how to find it. Now I'm monitoring it. I'm monitoring it a lot. So yeah. So what? She's, Mrs. L's no different than me, researching the case, monitoring the court's document. Comments expressing bias in favor of the plaintiffs and against the defendant. So what? I caught myself. So what? She is not a juror. She is not under oath. She is not under any restrictions not to talk about the case to anybody, not to do any research, etc., etc., etc. This is utterly and completely irrelevant. It means nothing. All right. Express concern over the amount of time plaintiffs had remaining on the total time allotted by the court. Everybody that was in favor of the plaintiffs, everybody that was rooting for the plaintiffs was very cautious of the clock. And then, come on, don't burn out the clock. Don't burn out the clock. That was on everybody's mind. You could see it. And again, it was one thing that Greg Anderson noted, I believe on Megan's streams, if anybody, Mrs. L or the juror, if anybody, the jurors were the worst people to ask about the time, because at the end of every day, the judge announced how much time each side had, kind of like they did in the Johnny Depp Amber Heard trial. At the end of the day, judge said, okay, plaintiff's got this much time, plaintiff has this much time, defense has this much time. The jurors were out of the room. The jurors didn't hear how much time there was. So that argument kind of shoots itself in the foot. The jurors were probably unaware of how much time that they had. Sharing a photo of juror number 1 on the day they announced the verdict, showing him dressed up in a suit in preparation for the announcement of the verdict for post-verdict notoriety. Hey, so what? That's a big statement from the court saying, you're done here. Go out, talk to people or don't talk to people. Nothing wrong with getting your 15 minutes of fame. He's been released as a juror. He can do whatever the hell he wants, and he can dress however the hell he wants. Hey, if this is something you want to ride to 15 minutes of fame, go freaking ahead. You are not a juror anymore, and your wife never was. So what? Now, if there had been, pictures uploaded before the verdict, if there'd been statements made before the verdict, this may be a completely different conversation. But after the verdict, after the juror's been released, after they said you're no longer a juror and you can do whatever the hell you want and say whatever the hell you want or not say, go and do. On November 10th, 2023, following the verdict, Mrs. L immediately posted to after the verdict? Okay, so freaking what? Mrs. L, so double freaking what? Immediately posted to a pro-plaintiff Facebook group called the Take Care of Maya, where she thanked everyone who stuck up for juror number 1, presumably referring to defendant's motion to disqualify juror number 1. That same day, juror number 1 posted a comment to the same group suggesting that he was aware that defendant had moved to disqualify him as a juror. Oh, I don't think he said that. I don't think he said that at all. What he did say was, quote, while the other jurors were escorted down to be transported, I was asked to remain by the SCSO lieutenant. Oh boy, I'm in trouble once again. But it was just for some security talk about that. Oops. I don't see anywhere where it says I was aware that the defendant had moved to disqualify me. And so what if he did? Obviously, juror number 1, he keeps using that word, obviously. I don't think it means what he think it means. Juror number 1's knowledge of the disqualification motion. Where does it say he had knowledge of the disqualification motion? indicates he was communicating regarding the case with others or accessing information outside the trial, notwithstanding this court's instruction to the contrary. The motion to disqualify juror number 1 would not have been known to him unless he were communicating outside the courtroom with others, inferentially his wife. Okay, we haven't even established that he knew about the goddamn thing. Show me a piece of evidence. And again, I like what MG Law is saying. This is a specific one where I would like to say, okay, here is your order to show cause. You got two choices. Submit some evidence that he was talking about the motion to disqualify him when he said he was in trouble again, or open up your checkbook. Those are your two options, pals. This is one where I would use that. Because there is nothing to indicate, nothing at all to suggest that when he said, I'm in trouble again, that he was talking about knowledge about a motion to disqualify him. And then, not only have they not established that, but they don't even draw a line. They don't even provide any type of link whatsoever between that knowledge and Mrs. L, Mrs. Juror number 1, that asserted that claimed knowledge. They just say, well, inferentially, that his wife, he got it from her, inferentially, which means they don't have a scrap of evidence to support that. Inferences. They're just inferring, using a little bit of deductive reasoning, that's not evidence. I'm sorry. Juror number 1 remained active on the Facebook group, liking comments suggesting he be careful regarding what he says to avoid overturning the verdict on appeal. Okay. Juror number 1 also began posting comments to the same YouTube channel Mrs. L was active during the trial. So, on November 11th, 2023, juror paid $100 to super chat his comment to host Rob, quote unquote Rob Law and Lumber, stating he would be happy to discuss the case with him. Well, the only problem I have with this sentence is that he gave Rob $100 and not me. So what? He's not a juror anymore. He can give Rob $10,000 if he wants to. Sure, Mrs. L may have a problem with that, but and he'd be happy to discuss the case with me. You know why? You know what? Because the judge frickin' said he could discuss the case with whoever he wants after he's no longer a juror. The judge specifically said he can do this. What? When Rob advised juror number 1 to consult with plaintiff's counsel before speaking publicly, juror number 1 paid Rob $2 to super chat his comment stating agreed. Now, in the motion, I think there was some extra dirty pool there. The way they had worded this in the original motion was that juror number 1 paid $100 to Rob, and Rob said, consult with plaintiff's counsel to avoid speaking publicly, and then he paid Rob the $2 as an acknowledgement of legal advice or something like that, which I thought was a pretty sneaky, shitty, dirty, underhanded thing to do, where they were trying to make it seem like there was some sort of lawyer-client relationship with Rob and juror number 1 by saying he gave him this money, Rob gave him advice, and then he gave him extra money as a thank you for providing the legal advice. I thought that was a pretty, if it was unintentional, it was a horrifically poorly crafted statement. If it was intentional, then shame on them. That was a dirty, underhanded thing to try to assume and try to establish. So that's my thoughts on that. On November 19th, 2023, juror number 1 posted to the Facebook group chat stating that he was listening to counsel. Okay, and then regarding the anticipated motion for a new trial that serves the basis for this affidavit. This comment suggests that he spoke with plaintiff's counsel who advised him the defendant would be moving for a new trial based on his misconduct. Look, this goes back to when I was doing the Zachariah Anderson trial. It was like day 1 or day 2 of the trial. I realized that Zachariah Anderson's sister and brother were in the chat, and I vetted them out and found out it was him. I'm like, holy crap. And they said, oh, we'd love to come on and talk to you about this. And I said, don't do anything. Here's the difference. All this shit with Rob was going on after the trial, so it made zero difference. I mean, it was completely irrelevant. But with the Zachariah Anderson thing, I just said, look, the trial's going on. Talk to Zach's lawyer, see what to do, but lay low in chat. Don't just view it as much as you can without comment, and don't super chat me after it's over. I'd be happy to interview you again after it's over. So, because you don't want to do anything, you don't want to say anything. So this is a completely red herring, because not only is that a normal thing to do and a normal thing for the plaintiff's lawyers to say, look, this might have some ramifications. Don't do it, or don't say this, or don't talk about this. Might be an issue for appeal, et cetera, et cetera. He can still do it if he wants, and it's after the trial, so it doesn't really matter at all. Juror number 1 seemed to enjoy his status as a hero amongst these pro-plaintiff platforms. I don't know if he ever held himself out as a hero. Anyway, making posts in the Facebook group regarding his involvement and joining several post-trial YouTube streams to share his comments about super chat function. Using the super chat function. Well, and he and Mrs. L, she gave a little bit of a super chat here today, which I'm grateful for. And he's been on here before as well. He's made the rounds. So what? Hell, if someone was talking about me, I'd be fucking watching it. I'd be freaking watching it too. And be saying, hey, thanks to them as well. So what? Oh boy, my voice went up a bit there. Gotta calm down. Juror number 1's eagerness to achieve this post-trial notoriety was demonstrated through his questioning of the witnesses during trial and implied research. That's a stupid sentence. That's just a dumb, stupid sentence. I don't have any other way to explain it. For juror number 1, for example, juror number 1 asked Maya Kowalski about creature comforts. Oh, my Lord in heaven, creature comforts. I just released about a 3.5 minute, about a 4-minute clip of Megan and I discussing the creature comforts part of the trial. You can go check that out later if you want, or if you missed it the first time. Juror number 1 asked Maya Kowalski about creature comforts during the trial, a term that was regularly used on Dr. Kirkpatrick's RSD Foundation website, but never once brought up during the trial. This is where we are very, very nearly crossing the line into perjury, because you all, using your collective hive mind, within a matter of minutes, told me which witness actually used the term creature comforts during the trial, what day it was said on. So, Jen S., when will the court decide on this? There's a hearing on the 15th where they're going to give arguments on all of this stuff, and then the judge will consider it, and it could be a day, it could be a week or two before he renders his decision. But I would expect it to be worked out by the end of the year. So in the next few weeks. But yeah, it's clear another witness used the term creature comforts. What was it, 8 or 9 days before juror number 1 brought it? But it's also a common term that people use when you're saying, did you have your things? Did you have your stuff around you? And it was so cute because Maya had no idea what he was talking about. She thought he was talking about his stuffed animals. She thought he was talking about her stuffed, asking if she had her comfortable creatures with her, not her creature comforts. Taken together, the evidence herein establishes a reasonable belief, bullshit, it does not, that juror number 1 engaged in improper communications with Mrs. L during the trial and conducted outside research on the case during trial. No, it doesn't. Not in the slightest. Moreover, there is reason to believe that Mrs. L was sharing information obtained from juror number 1 with the public. Oh, well, let's find out, shall we? With the public and plaintiff's public advocate and de facto agent. Again, de facto agent, that's a legal term. That means things. Show me how she was the plaintiff's agent in fact. Show me where she got her marching orders. Show me where she was authorized specifically to speak on behalf of the plaintiffs. Show me any evidence to that. Or is she just some true crime woman sitting out there in the gallery that's interested in this, who just happened to make friends with people? Likewise, Mrs. L shared information obtained throughout the trial to juror number 1. Where is the slightest fucking evidence of that? And I meant to use it that time. Where is the slightest piece, the slightest hint of evidence that that actually happened. Mrs. L shared information obtained throughout the trial to juror number 1, who was under explicit instruction not to communicate or research anything about. There's another good one for an order to show cause. Drag Shapiro's ass up there and say, "This is your sworn statement. Show me the evidence you base that statement on. Show me a single shred of evidence that Mrs. L shared information obtained throughout the trial to juror number 1." This is sanctionable. This is sanctionable, in my view. In addition, it appears based on public court records that Deborah Salisbury, the attorney representing Jack Kowalski in the underlying DCF proceedings, and who served as a witness in this case and appeared heavily in the Netflix documentary Take Care of Maya, was an attorney involved in Mrs. L's 2007 domestic relations proceeding. This was not disclosed in juror number 1's jury questionnaire. It asks, do you know this person? Now, I mean, she's here and she can correct me if I'm wrong, but my understanding is they weren't together in 2007, and there's no indication that she acted as Mrs. L's lawyer, that juror number 1 knew anything about this woman's existence. There's none of this. There's none of this has been shown. Juror number 1 also denied ever seeing Take Care of. So denying he ever, they're just assuming that he saw it. He denied it. So that's obviously a lie because he obviously saw it without a single shred of evidence that he watched it. I haven't seen it. It shows up every time as a recommended movie every damn time I turn on Netflix, but I haven't watched it. I haven't watched it yet. I know it exists, but I haven't watched it. I didn't know it existed until I saw someone mentioning it in chat. Hibble Lover says, correct. We were not together, and I don't even remember her. She was not my attorney. So, to you, Shapiro. Again, that would be a great order to show cause. I want these guys to have to, and not because of the trial or any information, as a professional in the same profession as these defense lawyers. As a professional who has done this for what, 28 years now, 27, 28 years, however the hell long I've been doing this thing, in the same profession, sworn to the same standards of professional conduct. I want some checks to be written. I want some pain to be felt for acting like this, for acting in this manner. All right, well, let's have another little palate cleanser here. A big collective sea ship's bell for everybody here. Let's go, Brandon, with another $5. My autocorrect messed up and I refused to fix it. All right. We'll just let it say whatever. Your previous super chat is open to the interpretation by the masses. It's art. It's modern art in text form. And Christina M. Quiroz, member for 9 months. Thank you so much, Krista. I think I just called you Christina. If I did, I apologize. Thank you so much, Krista. Love your videos, Lawrax. If they find that because of juror number 1 wife comments and actions are a problem, would they also find a problem with the lawyer's wife's actions since she was making comments? Oh yeah, we're gonna be getting to that. I saw someone ranting about that in the comments in one of my videos, saying like, Megan was a bad journalist and Megan was a fraud or whatever because she's getting upset at the plaintiff's lawyer for crowdsourcing the defense lawyer for crowdsourcing information. But you missed the point. The point is, dude, or ma'am, I think it was a dude, is that Megan was calling out the hypocrisy of the defense lawyers. They were actively farming for information about jury misconduct, but specifically juror number 1's misconduct from Reddit and other online sources, digging 20 years into the guy's past and other bullshit like that. Not only was the defense lawyer himself making comments, but his wife was actively doing, and she had very much had a pro-defense bias. So they're literally crowdsourcing through social media. The lawyer and his wife, they're crowdsourcing and researching and getting opinions through social media in order to attack someone who allegedly did the same thing after the trial was done. It's the utter hypocrisy of that just, it should make your damn head spin. Self-awareness and irony just they've taken a vacation at this point in this trial. We're condemning juror number one and juror number one's wife for using social media. How do we know? How do we have these allegations? Because we crowdsourced information through social media. Me and my wife. I mean, that's pretty stupid. And again, it's all irrelevant. I haven't seen a single thing to indicate for 1 second that there was any juror misconduct. That's the bottom line. So yeah, I think it's pretty bad, and it's pretty hypocritical, and it's pretty pathetic, really. So to me, it's a problem. It's not a problem for either side to do it. That's the takeaway from this. It's not really a problem for either side, but it's pretty damn hypocritical for one side to use that crowdsourced information to attack someone else for using crowdsourced information. The DCV Titan, thank you so much. Obviously and obliviously, same thing, right? It must be the same thing because I read them the same the first time around. Obviously and obliviously, same thing, right? Yeah. Koala T, obviously, is palpable. It's palpable. It's palpable. It is. There's so much palpability going on. Let's go, Brandon. This attorney really wants to test his hypothesis on why they call Rob Big Daddy Wood. Thank you for that. And the Chugi Show live. Thank you so much. Wish Jules could sue them. Such BS. I want sanctions. I want sanctions. Give me some sanctions. Sanctions taste good. All right, we've had our little palate cleanser. My voice is getting scratchy. I think I actually need a legitimate, real palate cleanser. Give me a second here. Oh, hey, do y'all like? Oh, look at my little Maker's Mark Christmas sweater. Isn't that so cute? There you go. That's what we should have. Rob's got his robot jury. I should have like Maker's Mark sweater bottles. That's what I should have. Yeah, this is a Christmas bottle they release every year. I got my hands on one this year because I've always wanted one of these Maker's Mark sweaters. Yeah, we need to get like nine of these set up behind me, and I can have my drunken jurors. All right. Thanks. Sorry about that. There we go. Feels a little more lubricated. Yeah, go ahead. Have fun with that, chat. On October 26, 2023, juror number one submitted several proposed questions to Dr. Sally Smith and Bonnie Rice at TGH. On October 27, 2023, Mrs. L posted a comment about Bonnie Rice, mirroring the points her husband tried to make with his questions the prior day. So they're saying that juror number one asked some questions on October 26th, and then the following day, she posted comments about it, talking about the question her husband asked. Again, put a big SFW question mark next to that one. So effing what? It was the next. Now, if she would have given this question the day before and her husband repeated it verbatim the next day, then we're into some seriously deep shit. But this was, he asked the question and then she allegedly went and tried to explain it in more detail the next day. So, guess what? That's what all of us commenter types did that commented on it. We would do that with lots and lots of the jury questions. We would say, okay, this seems to be what they're actually asking. This seems to be why they're asking it. This seems to be the information they're trying to elicit. Oh my God, that looks really bad. They really, really hate these witnesses. Everybody was doing that. So below is a chronological outline of Mrs. L's postings, obtained and reviewed to support defendant's motion for a new trial, motion for jury review, motion to open discovery into evidence of juror misconduct, and motion to preserve evidence. Mrs. L commented on Recovery Addict's YouTube stream on 10/13/23. The live stream took place contemporaneous with the trial proceedings of the day, meaning Ms. L was watching the trial and listening to real-time commentary from Recovery Addict at the time of her comments. So fucking what? Oops, I said it again. Sorry. So effing what? Ms. L made the comments depicted in Exhibit B. Mrs. L commented on Law and Lumber's YouTube stream on 10/13/23. The live stream consists of a reaction commentary on the trial proceedings on the day and took place after the trial day was over in the evening. Double so effing what? Mrs. L made the comments depicted. Okay, this is where they have all of this stuff in the listed in the other exhibit. Mrs. L commented on Recovery Addict's YouTube live stream. Notice again how you're not hearing anything about Mr. L, the actual sworn under oath, told not to do stuff juror. Notice you're not seeing anything about him here. Nothing about what he did. Mrs. L commented on Recovery Addict's YouTube stream on 10/17/23. The live stream, so it's like 4 days later. The live stream took place contemporaneous with the trial proceedings on the day, meaning Ms. L was watching in the trial and listening to real-time commenting from Recovery Addict at the time of her comments. Mrs. L commented on Recovery Addict's YouTube live stream on 10/18 next day. The live stream took place contemporaneous with the trial proceedings, meaning she was watching it real time. Mrs. L commented on Law and Lumber's live stream, YouTube live stream on 10/18/23. Consisted of reaction to the trial proceedings of the day and took place after the trial date was over. Ms. L commented the next day, 10/19/23, on Recovery Addicts. It was contemporaneous. We'll just keep saying it was contemporaneous rather than contemporaneous for the trial proceedings of the day. And meaning Ms. L was watching the trial and we're listening to real time commentary from. We'll just say it was contemporaneous. That'll help us get through this a lot faster. Ms. L commented on Law and Lumber on the same day, 10/19/23. The live stream consisted of reaction commentary, and it was after we'll say after the court was over for there. And again, next day, Mrs. L commented on Recovery Addict's YouTube live stream on 10/20/23. It was contemporaneous with the trial proceedings. Then the next day, 4 days later, Mrs. L commented on Law and Crime's YouTube live stream. See, Mrs. L, you're better than that. Why are you watching Law and Crime? We just call them Law and Cuck around here. All right, there's my first problem I have with something that Mrs. L has done. That's my first problem that I have with absolutely anything she's done so far. She watched Law and Crime. Other than that, I don't have any problems with anything she's done. But that's a big problem. The live stream took place contemporaneous with the trial proceedings. Mrs. L commented on Recovery Addict's YouTube live stream on 10/25/23. It was contemporaneous with trial proceedings. And later that day, she commented on Law and Lumber's YouTube live stream, consists of reaction commentary after the trial was over, that for the day. Next day, commented on Recovery Addicts. So they're just going through. They're not even saying what was discussed in the text messages. They're just referring you to the texts. And now they've all been heavily redacted. I thought about showing some of the comments here that were being made, some of the exhibits, but they're essentially all just gigantic black bars at this point, which I'm satisfied with because it's all bullshit and we don't need to see it. So yeah, I'll go through all of these things. On October 30th, 2023, Ms. L physically attended the trial proceedings in this case where her husband was impaneled as juror number 1. Juror number 1 said nothing of her presence. Why the flip should he have to say anything about, hey, everybody, look, there's my wife. My wife is out there in the gallery. Why? I wonder if any other jurors' families were in the courtroom at any point. Just curious. I wonder if anybody was. All right. Well, on October 30th, 2023, Mrs. L can be seen in video footage in the courtroom for the entire day, often seated next to and speaking to Jules. Still shots of footage from Law and Crime, which live streamed the trial proceedings, are depicted in the slides. Jules is a social media influencer that acted as plaintiff's public advocate throughout the trial and subsequent to the verdict. Jules made a name for herself and was sought out by several social media influencers. Yeah, was she acting for the plaintiffs as their public advocate, or was she acting as her own person to get sought out by several social media influencers? Or was she just someone who happened to be there who likes true crime and just got caught up in it? I don't know. But I haven't seen any evidence to say she was the plaintiff's public advocate throughout the trial. She was sought out by several social media influencers with large audiences following along with this trial. Because as a daily attendee at trial, she offered commentary on the one aspect of the trial that the online viewing public could not observe: the jury. She was on some other lawyer channels as well who didn't get named in this. So, lucky you, you all know who you are. Oh my God. There's one aspect of the trial the online viewing public could not observe, the jury. How many people were doing that during the Johnny Depp trial? Jeebus effing Christmas cakes. There was people on every single channel and every single YouTube channel known to man saying, I was in the courtroom and this is what the jury was doing. This, juror number 1 did this. Juror number 2 looked like that. Juror number 3 was wearing this. And that's what people do. And there, spoiler alert, there's actually paid people. I don't know if they used any jury consultants for this case. I'm pretty sure they did. But there are actual people whose actual jobs are to sit in court, watch carefully and observe the jurors, and then go back and report to the lawyers how the jurors are acting, who seems to be on board with them, who seems to be in the middle, who seems to be against them. Jury consultants make cash. They make piles and piles of it, doing exactly what Jules was doing essentially for free. So Jules, maybe there's something you can look into, being a jury consultant. Evidence from social media sources of Jules' public advocacy, closeness with plaintiffs' trial team, plaintiffs' experts, and Mrs. L is depicted in this exhibit. Mrs. L commented on Recovery Addict on 1031. Let's see, going back to all this. Law and Lumber, more Recovery Addict. Live stream took place, blah, blah, blah. Let's see, comment Law and Lumber, Recovery Addict. They're just going through, there's like 81 of these, so... And we're almost to the end here because we've almost scrolled through all of them. All right, here we go. I think this is where we pick up again, right? Yeah. Paragraph 52. Dracula. On November 10th, 2023, juror number 1 and his wife posted to the Facebook group, Take Care of Maya, which is a plaintiff favorite internet community. So effing what? The comments of juror number 1 and his wife, which were posted at various times on and after 11/10/23, are depicted in Exhibit B, November 11th. We're approaching present day, so we're almost done with this. We've got like 2 pages left. On November 11th, 2023, juror number 1 also joined the Law and Lumber YouTube live stream and paid the host $100 and commented that he was happy to discuss the case with him. We've gone over this several times. Doesn't matter. So what? Over trial. He's no longer juror number 1. He's former juror number 1. The host referred juror number 1 to plaintiff's attorney Greg Anderson with Nick Whitney to discuss. No, he said discuss it with. He did not name them. See this. All right. I'm starting to nitpick. Let's get back to the big picture. The host referred juror number 1 to plaintiff's attorneys Greg Anderson and Nick Whitney to discuss before having juror number 1 on the show. Juror number 1's comments from 11/11/23 are depicted. On November 15th, juror number 1 joined the Law and Lumber YouTube live stream, which hosted plaintiff's expert Dr. Joe Corcoran. Dr. Corcoran spoke about his views that the video of the then current CEO and then interim CEO of Johns Hopkins All Children's Hospital should not have been excluded in the punitive damage phase. And that if it had not, you can ask juror number 1, that would have put another 0 on the punitive damages. In response, juror number 1 commented that they would have added 14 zeros. It doesn't matter. And you know what? This is kind of a self-own. It didn't come in. So it didn't add 14 more zeros. So that couldn't have been any misconduct because it wasn't there. What do you want? Do you want it to be in there? And it isn't any misconduct. I don't understand this. I honest to God don't understand why this is an issue. They're talking about something that the juror never saw. The juror number 1 seeing this on Rob's stream with Dr. Corcoran was probably the first time that he was aware of this. So how could him not being aware of something and not paying attention to it and not adding 14 zeros because of it be improper jury conduct? That's proof he didn't fucking talk about it. That's proof he wasn't getting his information from elsewhere, because this would have been a big piece of information to pass to juror number 1 and let him know that this was there. This may have added 14 more zeros. They are proving that he did not have outside communications regarding this point. This is a self-own. I don't understand how this can be evidence he did something wrong. I'm confused. I'm confused by this one. I really don't get it. On November 19th, 2023, juror number 1 posted to the Facebook group Take Care of Maya, stating that he spoke with plaintiff's counsel and anticipated defendant's motion for a new trial that serves as the basis for this affidavit. The foregoing facts demonstrate. Okay, now we're getting into the I know everything and I'm swearing to them part. The foregoing facts demonstrate that juror number 1 violated the court's instruction and Florida law by impermissibly sharing information about the trial with his wife, obtaining information outside the evidence admitted at trial, and prejudging the evidence in a biased manner against Johns Hopkins All Children's Hospital. The foregoing facts demonstrate juror number 1 engaged in misconduct that prejudiced the case against Johns Hopkins All Children's Hospital and undermined confidence in the integrity of jury trials in the state of Florida. Verification. I swear that everything is true to the best of my knowledge and belief. And there he signs his name. Where do we have his signatures up here? Ethan R. Shapiro, Esquire. Yeah, that's an icky read, but we got through it. And as you saw, most of what was there is repeated from the motion. They put everything in the motion, and then to support that motion to do all of these things, they had to have the lawyer prepare an affidavit saying that everything that was in the motion I believe to be true, and here's how I know it. And that's why his affidavit is in there. It has the same mistakes, it has the same errors, it has the same false statements, such as the creature comforts was never used. It has some definitely demonstrably false statements in it. He's signed it. That's there. Now, we read through the plaintiff's motion responding to this the other day, and attached to that are also exhibits. And one of those exhibits is an affidavit from Greg Anderson. That's what we're going to look at here next. But before we do that, we have one super chat here from Jinver. Thank you so much, Jinver. Can the judge order the defense lawyers to 5 years in the care of Jay Hatch for this motion? I like that. That would be fair and equitable, I believe. Oh, Jennifer Okoto. Oh, yeah. Okot. Wow. Okokoto. Was it okay talk? How's that? Sorry. If not, it's comical. It was funny. It was funny the first maybe 2 times I read through it. Now I find myself getting more enraged than finding the humor in it. Just as a professional in the same profession as the people that wrote this motion, I find it's vile and disgusting, and it's less than weak. You saw everybody, and the Reddit, there's the pro defense Reddit group, Maya Kowalski Free or whatever the hell that is. They're having a fit. They were having a fit that literally every single lawyer on YouTube that reviewed this said it was bullshit. They were all excited when the lawyer was reviewing. Like, oh, the lawyer he's the most balanced and neutral one. And about 20 minutes into his stream, they started posting, oh, now he's been brainwashed too. Oh, I thought he was the good guy. No, he's just a shill. They were up in arms over the fact that not a single lawyer that reviewed these documents, that reviewed these motions from the defense, first of all, could believe what they had put on there, and second, just found them utterly laughable. They that's how bad it was. If any of you have any examples of any lawyers that reviewed this in a live stream manner where I can go watch it and see their logic and their reasoning that found this to be a good solid affidavit and a good solid motion that warranted a new trial, please email it to me, because I would love to see it, because literally 100% of the legal commentary from lawyers that have reviewed these motions found them utterly laughable and completely without merit. Oh God, yeah. On Megan's stream, I didn't see much of the other lawyer on Rob's channel, but on Megan's channel, Greg Anderson had a field day with it, with the motion. He thought it was hilarious. And speaking of Greg Anderson, we've got one more super chat that came in. We'll read that. And how are we doing on? Have we got to? No, we're not to Doggo Cam yet. We're about like 25. All right. The super chat here from Twisted Logic. Hey, how you doing? Twisted Logic in the house. So much ado about one juror. If it were him against the rest of them, this verdict wouldn't have gone the other way. It's like saying the others didn't have their own mind. That is a very, very good point. They're making this sound like it was a jury of one. There were 6 jurors. There were 6 jurors, all actively thinking, all actively analyzing, all actively reviewing and reaching their own conclusions. So to say that everything was, and they tried to do that in the motion. In all the motions they've said, they keep using phrases like under the leadership of juror number 1, the foreman. Any of you that have ever been on a jury and have been selected to be the foreman, you know that you have no power whatsoever. Your job is essentially limited to, do you have occasionally the jury foreman will read the verdict. If in those cases, your job is essentially limited to saying, have you reached a verdict? Yes. Is it unanimous? Yes. Please read the verdict. This is our verdict. Da, 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 da. And answering the question, is this your actual verdict? That's kind of your entire power and authority as the foreman of the jury. You're just elected to be the spokesman for the other people on the jury. You get nothing. It's not a big thing. It's not a big power play where you can assert your authority as juror number 1 and bend people to your will. Try that. People don't like it, and they would probably rebel against you. And again, if juror number 1 has the power to turn, assuming that all 5 of the other people wanted to let Jay Hatch off the hook, if juror number 1 has the hypnotic abilities to walk into a room and hypnotize everybody and brainwash them into agreeing with him after an hour, I want those powers. Yeah, you do nothing as a jury foreman. But they kept trying to couch this motion in the terms of under juror number 1's leadership in his role as foreman to sort of make it seem like he was somehow being super influential. But by doing that, as was just pointed, you're really disregarding the validity, the integrity, and the mental capacity of the other 5 jurors. They could have told juror number 1 to shut the F up. They could have, at best or worst, they could have made it a hung jury. All right. Exactly, Daily Quick Bites. They polled the damn jury, and you could hear in their voices essentially, you're goddamn right, that's my verdict. They just couldn't say it like, yeah, go back and listen to that polling the jury. You heard lots of yes. Yes, that is my verdict, in fact. Yeah, you heard a lot of inflection in just those very few words. So that's a good point, Dave. And again, even if they weren't emotion-laden responses, they were individual responses. Is this your independent verdict? Is this your independent verdict? Yes, yes, yes. Not one of them said, no, I really wanted to be on the defensive side, but juror number 1 used his magic powers, and I was brainwashed and coerced into voting the opposite of what I really wanted to. Nobody said that. Kelly Weller says the final juror polled was juror number 1 after a pregnant pause. Yes. Yeah. So, all right. There we go. Let's read the much shorter and much more to the point affidavit of Gregory A. Anderson, lawyer for plaintiffs. This is him responding to that affidavit and the other motion. And what he does here is he counteracts what they've said. He counters that, and he also points the finger right back at them for their own, the defense lawyer's own alleged misconduct. Excuse me, I'm gonna cough here. As long as this came in before we jumped in, let's look at Vitakasu. Thank you so much. I love how Rob was more insulted. The defense put his actual name in parentheses, but left his channel out of parentheses. Yeah. Law and Lumber, aka Rob. All righty. Well, Irish Rover says Anderson's response should be WTF, and that's it. Lol. Or as we've been saying.
Everything that guy just says is bullshit. Thank you.
Let's see how many pages it takes him to do that. All right, here is the oldie motion. Let's see how much can we make that any larger? Nah, that's good enough. Oh, Squid Proco, you're gonna miss the best part. Come back later. Come back later and watch this. This is the best part. This is where the tables get turned. This is where the rubber hits the road. Well. Been there, done that. Oh, thank you so much. Been there, done that says doggos. We're like $5 away from unleashing Doggo Cam, but what the hell? What the hell? We'll get through this last motion here. Let's we all want to see Sleeping Dog, don't we? Let's bring up Strawberry's camera. Yoda, again, it's too late. Yoda has already shuffled off to the sofa where Yoda likes to sleep. There's some Strawberry. My cohort Strawberry right there. So let's embiggen Strawberry just for a quick second. Oh, you big lump of meat. I'm trying to zoom in the camera here. All right. Let's zoom in like right there. That's good enough. She ain't gonna move. That's her permanent resting position. She'll wake up at some point and head to the sofa in the middle of the night. All right, there is Strawberry. Thank you so much for
release the
goal unlocked. Thank you so much. Been there, done that. All right. Oh, we do have one. Oh, we do have one more that came in. Thank you so much, the DCV Titan. This whole document was, Your Honor, we seriously effed the dog. I mean, absolutely destroyed it. Can you please take these straws we grasped at and give us another dog? Kinda. And that's what Greg Anderson is going to say here in his affidavit. Adriana, thank you so much. Can we donate to get you a second camera to put on the couch so we can get Yoda too? StreamYard only allows you to have one extra camera. The only answer to that is we have to hit the achievement earlier. Anyway, this is not a grift stream. That's going to happen on the 15th is the Merry Effing Christmas stream. We're going to do an Effing Friday on the 15th. So keep that in. Let's present the document. All righty. Yes, it's Ariel says it's a potato. It could be a potato, could be a loaf of bread, could be a larva of some sort, but yeah, it's kind of what it is. Declaration of Gregory A. Anderson, Esquire. I, Gregory A. Anderson, pursuant to Florida Statute 92.525, declare under penalty of perjury. See, I like how he put that right out there in front. This is under penalty of perjury. That I make this declaration based upon my personal knowledge of the facts contained herein and state. I was lead trial counsel in this case and made all command decisions as to strategy, tactics, scope of questioning, choice of jurors, questioning, and every other aspect. My partner, Nick Whitney, assisted on a number of the decisions, but the ultimate decision on all of these was mine. Right there, top-notch, grade A, #1, government certified and inspected, signed, sealed, and delivered professional leader right there. He takes responsibility for everything. Buck stops with him, as any good leader does. He takes responsibility. We're already off to a great thing here. No, I didn't miss her super chat. I just read it just a second ago. So you're asking if I missed a Take Sue's super chat. I just read it. All right. Anyway, he makes all the command decision. He's sticking by him. He's saying it's me. You have a problem with it. You got a problem with me. I have read the defendant's motion regarding juror #1 and the attached affidavit and exhibits by Mr. Shapiro. So he's read Mr. Shapiro's affidavit, and this is what he's responding to. At no time, that's a definitive statement. At no time did I have, nor have I ever had, any conversations directly or indirectly with juror #1. Even up to the moment of this declaration. I have neither met with him, nor have I received information about or to him, or at least until the filing of the defendant's motion. In fact, of all the jurors, I had the least eye contact with juror #1 during the trial. And that's a very interesting statement, because conversely, during their motion to dismiss juror #1, in the judge's reasoning for dismissing the motion to get rid of juror #1, he said, I had the most contact with juror #1. He's the juror that's sitting closest to me, and everything I've seen, he was paying attention. He was taking copious notes. He was asking appropriate questions. He was showing engagement, and I haven't seen any evidence whatsoever of misconduct. So yeah, he's made some declarative statements here. At no time did anything that he did or did not do have any effect on my overall trial strategy, with the exception of a decision as to whether or not to keep him, as opposed to bringing in the first alternate juror near the end of the trial. When the defense filed a motion to disqualify juror #1, I confirmed that the first alternate was the gentleman seated third from the right with a gray goatee, who appeared to be older and generally smiled at everyone upon coming in and leaving the jury box. That included the bailiff, the court, and both sets of counsels. Throughout the trial, as is my typical practice, I closely monitored the questions submitted by juror #1, and those questions I could discern from the first alternate. My purpose in doing so was to gauge the jurors' reactions to try to discern what questions or reservations remained in the jurors' minds that needed to be satisfied in order for us to prevail. Every experienced trial attorney does this. He's absolutely correct. You look at what the jurors are doing. And again, as I said, sometimes you even pay the jury consultants to watch them and monitor and check their body language and do all this other stuff and come back and say, okay, this one's with you, this one's against you. I don't know about this one yet. The questions from my review and memory and their context from juror #1 were incisive and straight to the point, as one would expect from someone with a background in law enforcement. As the court has pointed out, all counsel knew of juror #1's law enforcement background from the voir dire process. We all knew about it. Questions from the first alternate tended to be favorable to our case. That does not mean that you can have an opinion, you can have questions, you can have thoughts, as long as you don't make up your decision, as long as you haven't formed any opinions about guilt or innocence or made up your mind before you go into that jury room for deliberations. You can have bias, and that's one of the questions. If anybody says, yeah, I have this particular bias, the question the judge asks is that bias, even with that bias, are you still able to fairly and neutrally weigh the evidence and render a fair and impartial decision, even with that bias. Yes, okay, fine. Or no, all right, hit the road, Jack. So having a bias, having an opinion doesn't mean you're doing anything wrong. It means you're human. You just can't let it prejudice your view of the evidence. Okay. Thus, I concluded that the first alternate was more of a sure thing in terms of completing a jury that would ultimately decide in our favor. So he thought the first alternate would be perhaps even a better person. Oh, sorry. Question from the first alternate tended to be favorable to our case. More of his body language when considering our witnesses versus those of the defense appeared more positive, at least from my perspective. So he thought the first alternate would be a better juror than juror number one. That's what he's saying. Juror number one, on the other hand, was a wild card. His questions of our witness at the start of the case were explorative and at times aggressive, poking holes in our theories and arguments. I had deep concerns over his reaction to our case. However, I was heartened by his questions to the defense, which were equally probing. My decision was that either would probably do well, but I did not have a strong read on juror number one. When it became clear that I had to make a choice, to make, it took me at least 15 minutes to draw the conclusion that I should probably go with the sure thing, i.e. the first alternate. So he just says it right here, I thought the alternate juror would have been a sure thing. We still don't know about juror number one. But then, standing at the lectern with the ultimate decision hanging in the balance, I realized that I had not spoken to the most important person there, which was my client, Jack Kowalski. He probably should have talked to Jack Kowalski a long time before that. But at least he recognized it and remembered it and went, all right, let's go back. I learned that Jack and Dr. Scott Richards, our expert psychiatrist, appeared to have a different assessment. When I consulted with Jack, although I cannot reveal privileged conversations, it became clear that Jack had weighed juror number one's and the first alternate's body language and questions to the, okay, they had their expert psychiatrist. So they apparently did have a jury specialist, a jury consultant. All right. It became clear that Jack had weighed juror number one's and the first alternate's body language and questions to the witness differently than I had. These factors were on my mind as I approached the lectern and ultimately decided to oppose the defense's challenge to juror number one. Awaiting the court's ruling, in no way did I agree with the defendant's allegations that against juror number one. My decision was purely tactical. Greetings from the hallway. Oh, we're going to get to the hallway here in just a minute, Darth Hideous. So yeah, he's saying that nothing juror number one did influence him. It was all a tactical decision. The records reveal that the basis for removing juror number one was thin, to say the least. Only my joining in it would allow it to happen, and the court noted this. So again, it's like saying, yeah, it was such a thin deal that the court wouldn't have allowed juror number one to be excused unless the plaintiff's lawyers agreed with it. They didn't agree with it. He denied the motion. Defense counsel noted this as well, at least by virtue of their reaction to my even considering it. I knew that this choice was ours alone to make. At no time did I draw any conclusions about juror number one being anything more than he appeared to be, a very intelligent former law enforcement officer who asked cogent questions and would give both sides a fair shot. Fortunately, the jury sided with us, but I remain confident that the first alternate juror would have contributed to a similar result if juror number one had been relegated to alternate status. As to the public observer known as Jules, I do not recall having a substantive conversation with her at any time over the 8-week trial. Then, during the jury deliberations, she brought her lunch down and sat directly across from the two rooms we had reserved for our team throughout the trial. And so she's sitting there in the hallway or whatever, directly across from the lawyers' rooms. She chose to sit in a position where she could, if she had wanted to pay attention, overhear potentially attorney-client privileged matters. Now, see, this is the thing. You have, and keep this in mind, you have lawyer-client privilege. Nothing that's said within that privilege can be revealed to anybody else. But if somebody overhears it, it's no longer privileged information, generally. So if you stand in the hallway and you have a conversation with your client in a crowded hallway saying, did you murder that guy? And he says, oh yeah, I stabbed him right in the eye and I watched him bleed to death right there on the floor. If someone overhears that, that is no longer a privileged statement. So By having Jules sitting there, they are risking having anything they discuss in that room become unprivileged and open information. So what does he do? He said, I do not believe that was her intent, though I am always cautious. I spoke to her and told her that I really could not have her sitting anywhere near my clients while we were discussing matters due to the privilege. She immediately understood and picked up her food and went down to the other end of the hallway. Mr. Shapiro's photograph reminded me that our dozen or so photographs taken of the Kowalskis, that out of the dozen or so photographs taken of the Kowalskis and our trial team after the verdict, and the photos of our trial team with experts from our case, and photos of the trial team with various persons from the gallery, and photos of the Kowalskis and the trial team with various media reporters, that there was one in which Jules is pictured. So of the dozens of pictures that were taken, Jules is pictured in one of them. Although we did not interact with her throughout the trial, she had been present on most days, and I felt a bit bad about excluding her from our area at the hallway earlier that day, so we honored her request for a photo. Certainly, she was not part of our trial team in any respect. There I'm saying, no, she was never our agent like she's being held out to be. Now, during the course of the trial, there was no settlement discussions between the plaintiff and the defendant. There was no decision to be made and no advantage to be gained by having any insider knowledge during the deliberations about what the jury was doing. The defendant had filed 3 nominal proposals for settlement, and settlement negotiations with J. Hatch had gone nowhere since the beginning of the case in 2018, even as late as the most recent mediation in June of this year. Succinctly, even if there was some plant in the jury who was communicating to us the progress of jury deliberations, there was nothing to be gained because there was no discussions. There was nothing to accept or reject. This is all conjecture, of course, because no secret plant or backdoor communications existed. Similarly, there were no joint decisions on major issues, although I did readily accept advice from Jennifer Anderson, Nick Whitney, and upon occasion, Kelly Perry with Samantha Lawrence. Even the input from my team of astute lawyers and paralegals was metered by me, and it is absurd to suggest that I, as lead trial counsel, took suggestions from random people in the audience. Sorry, Jules, you've just been relegated to random person in the audience status. You're not the alleged de facto plaintiff's trial spokesman. You're just a rando in the pews. Sorry. I like that statement. He's talking about how he makes his joint decisions on all these major decisions by metering what's going through all of his trial team. He said that it would be absurd that I, as lead trial counsel, took suggestions from random people in the audience. Notorious, Jules. Notorious. Hey, Law Nerd Debbie, thanks for being here. I heard at the time and have confirmed in the record that the court discharged this jury and instructed them that they may speak to whomever they wish to, with the caveat that none of the lawyers may approach them for comment. They can approach whoever the hell they want, but nobody can approach them. Other than that, they were free citizens to talk to whoever they wanted, however they wanted, about whatever they wanted. None of my trial team approached juror number 1 or any of the other jurors. That statement right there is the WTF mic drop. What are you talking about? He's not a juror anymore. He didn't do anything when he was a juror that you've proven, and he can do whatever the hell he wants to do after. Finally, as an officer of the court, here we go. Here's where the finger pointing by the defense, at the defense by the plaintiffs begin. Finally, as an officer of the court, I must point out my deep concerns over this motion being filed in the first place. That's what I'm saying. From my review of the reaction in the media and public forums, the defense's allegations have done drastic harm to the jury system. And I've said that to people personally, in text messages, in replies to comments on the stream. I think this motion has done far more damage to juries and who wants to be on a jury after this? It is a sacred right and duty to be on a jury. It's a sacred calling to put someone else's life and finances in your hands and to render judgment upon a fellow human being. I don't understand people that want to get out of jury duty. I think it's a solemn responsibility that we should all take very, very seriously. And and do out of a great sense of respect for the system. Maybe I'm weird that way, but when you go after, because you lose and your butt hurt, because someone reamed you out so hard at trial, because your butt hurt and you go after, you just don't like the verdict, you don't like the way it happened, you don't like the amount or whatever was the driving force, you go after personally one of the jurors, you dredge up stuff from his life 20 years ago to try to show some sort of misconduct. You go and you hunt and cyber stalk and dig through all of his wife's stuff. You sanction it. You encourage other people to do it on social media. You dig through their communications. You take everything she's done and nothing he's done and somehow impute her actions to him. Who the fuck wants to be on a jury after that? Who would want to subject themselves to that for 8 weeks, only to have the possibility that they're going to do this witch hunt against you? They're going to dig into your past, dig into your spouse's and your family's social media presence. They're going to file motions and try to bring you in for further interrogation. They're going to try to take your computers, take your cell phones, take other, your notes, and they're going to interrogate you and try to find additional evidence that you somehow did something wrong. Nobody is going to want to be on a jury if this kind of bullshit's allowed to stand. That's why I take offense with this. And it seems Greg Anderson shares that same thing. And any good lawyer worth their salt would take offense at this. So I must point out my deep concerns over this motion being filed in the first place. From my review of the reaction in the media and public forums, the defense allegations have done drastic harm to the jury system. The motion docks juror number one and his wife by revealing juror number one's full name and shared address in a footnote on the very first page. I don't consider that doxing, but it still didn't need to be done. The names, they put their names out there. They both, the day of the trial was over, or it was either the day or the day after, they made the Facebook post, they introduced themselves, they revealed their own name. So revealing the names is something they did. Their address, it could be found if you really were sort of weird and creepy and wanted to find their address, you could, but to put it on the bottom of the first page of your affidavit or of your motion, that was wrong, because it's not supposed to be there. If anything, it should be in an attachment or a separate document. It should not be at the bottom of page one, as we learned from Greg Anderson. So the motion docks juror number one and his wife by revealing juror number one's full name and their shared address in a footnote at the bottom of the very first page. There is a strident and at times cruel and malicious segment of the internet population that is dead set against the Kowalskis and anyone who supports their case. By placing juror number one in the public eye with his name, his wife's name, and their address, the defense places them at substantial risk of harassment and physical harm. The defense took no efforts to keep juror number one's personally identifiable information confidential or under seal, despite the court's great efforts in this regard. The court should be aware that the defense never conferred with me or my team at any time prior to the motion being filed. There was no attempt to contact me by phone or text to let us know what was coming or to cooperate to protect juror number one and his wife via a stipulation or other arrangement so that we would not challenge the defense's motion for failure to satisfy Florida Rules of Civil Procedure 1.431H. The defense's actions were in violation of this court's standing order regarding filing of motions. Oh, great. The defense, he's pointing out that the defense apparently violated the court's orders regarding how to file motions. What sanctions could be possible? Lots and lots of money. They could be forced to cough up lots of cash. The defense's actions were in violation of the court's standing order regarding filing motions, but much worse, it indicated defense counsel's reckless disregard for potential consequences that could befall juror number one and his wife. Pursuant to Florida Statute 92525, I declare under penalty of perjury that I have reviewed the foregoing. That's twice he said he's doing this under penalty of perjury. I like that. The foregoing declaration and the facts stated herein are true. Executed on November 27th, 2023. Now, Exhibit C. This is Jack Kowalski's declaration. What does Jack have to say about all this? Before we get to Jack and his declaration, let's read through a couple of these comments here. Where are we at here? Where's my? There we are. Hi, it's me and Strawberry. Me and Sleepy Strawberry. Adrienne has been a member for 11 months. Wow, it's been almost a year. Thank you so much. Bell for you. Hello, Senor Jeff and Vice Squad. Today is my birthday. Yay, and I love cake. Well, Adriana, we love your cake too, but here's a cheers for you. Happy birthday. Glad to have you here, and thank you for celebrating at least birthday morning with us. We hope you have a great and wonderful day, a wonderful month for Christmas, and a wonderful next turn around this little globe of ours here. Happy birthday to you. Your birthday is probably far enough. Did people give you joint birthday and Christmas presents? My sister's birthday is December 16th. Once I gave her a joint Christmas present. That's close enough. Here's your birthday / Christmas present. Well, I got a birthday / Christmas present in July the next year. So I went, we don't like that. I actually dated a girl after my divorce that had a birthday, had a birthday on Christmas, and I had learned from my sister, so we celebrated twice on the same day. Sometimes, so that's what we did. So thank you very much, and happy birthday to you. V takes two again. Thank you so much. I think also I remember the lawyers were admonished from carrying evidence which had not yet been admitted near the jury more than once. If that happened, then that would be a proper admonition. I didn't see that myself, but hey, I mean, if they're carrying hasn't been admitted anywhere a jury can see it, that would be a proper admonishment. And Ms. M. Lee, speak. That's a solid summary. Blows me away that their strategy and team didn't stop to think about how poorly they were coming across for all the Reddit interactions. One of two. Uh-oh. Gotta scroll up for 2 of 2. I didn't see the 1 of 2 part. Yeah. There we are. I'm surprised no one said, hey, you guys are missing the fucking point. Well, they use the term fucking here, and we're going to get to that in just a minute. But thank you so much for that. Deeply, deeply appreciated. All right, we're almost done here. So, declaration of Jack Kowalski, Maya's father. He's given a declaration. What is he going to say? I, Jack Kowalski, pursuant to Florida Statute 92.525, declare under penalty of perjury that I make this declaration based upon my personal knowledge of the facts contained herein and state. So this isn't allegations, this isn't inferences, this isn't innuendo, this isn't supposition, this isn't inferences from any other site. This is his own personal knowledge of the facts. Direct knowledge of everything he puts in here. That's what he's saying. I attended the trial almost every day of the trial, period, starting on September 21, 2023, and ending November 9th, 2023. I am aware of the motion filed by the defense team on November 23rd. This is where we get the explanation, Jack Kowalski's explanation. Oh my gosh, that's right. Lorraine W has just pointed out that my F Friday stream is the same day as the motion hearing. I'll think about that, Lorraine. Thank you for pointing out my poor scheduling abilities. All right. Dang it. Now I got to put my brain in gear and do some thinking. Oh, hey, you know what? Do you guys want to read the motion with me? How about that? Would that be more interesting and fun? How come or did I just miss everybody asking where the hell the affidavit is? No, nobody seems to have pointed out that it's not on the stream. So let me do y'all a favor and y'all can read along with me. How's that? Yeah, that's more fun, isn't it? There we go. Sorry about that. I was just looking at the screen going, me and the dog. Dog is greater than motion. We can't read legal vices. We're just used to it, says Mrs. K. Griff. Watching the dog. All right. Well, all right. I am aware of the motion filed by the defense team on November 23rd, 2023, specifically the part about my alleged interaction with quote-unquote Jules during the court's ruling on whether to disqualify juror number 1. The defense's motion alleges that after the court denied the defense motion to choose to keep juror number 1, I turned to Jules and nodded my head with a smile. This is false. If you watch the video linked in defendant's motion, I turned to Dr. Scott Richards, who is seated next to Jules in the gallery. Lie exposed. In fact, the video provided by defendant shows Jules with her head down at that very moment. Another lie of the defense lawyers exposed. At no point did I have any conversation with Jules about wanting or needing to keep juror number 1 on the jury. Yeah, why would he talk to someone in the audience about that? My purpose in turning around was to make eye contact with Dr. Scott Richards, our expert psychiatrist, who I found helpful in assessing the behavior of the various jurors throughout the trial. Of course, at that point, I was aware of the defense motion to disqualify juror number 1, and I was also aware of the identity and position of the first alternate juror. Leading up to that discussion in court, I had several conversations with Dr. Richards in which we traded our assessments and observations of juror number 1 and the alternate in the hopes of coming to the right answer. For that reason, I glanced back at Dr. Richards when the court made its ruling. I don't know who sounds more reasonable, who sounds more plausible. Which sounds like the right and correct version of what happened. Pursuant to Florida Statute 92.525, I declare under penalty of perjury that I have reviewed the foregoing declaration and that the facts stated in it are true, executed on November 2, 2023. Exhibit D. Let's see where are the, where's the, we need the FU affidavits. Aha, there we go. Right. So that's Jack Kowalski's story, which is pretty much exactly what Jules explained on whatever stream that I saw her explaining it on. I think it was on mine and Megan's stream, as a matter of fact. Well, all righty-roo. Now this next motion is by Gabrielle Carlson. Who is Gabriella Carlson, and what does she have to say? This is some serious finger pointing at improper conduct by the defense lawyers. Exhibit D is a Xerox picture of Anderson's middle finger. Nice eco-pass. All right. Yeah, no offense, but I'm looking at the expert, not Jules. It's pretty much the explanation. Yeah, 100% credible. Okay, all right, never mind. Well, I was about to go down another ADHD path, but we'll stay focused. All right, who is Gabrielle Carlson, and what does she have to offer to this? Oh yeah, misconduct, improper conduct by the defense counsel, Mr. Shapiro. I, Gabrielle Carlson, pursuant to Florida Statute 92.525, declare under penalty of perjury that I make this declaration based upon my personal knowledge of the facts contained herein and state I am a law clerk with Anderson Glenn LLP and assisted plaintiff's counsel throughout the Kowalski versus Johns Hopkins All Children's Hospital Inc. trial on November 23rd. On November 9, 2023, shortly after the verdict was read, I exited the courtroom before the court took a recess ahead of the punitive damages trial. My purpose in exiting was to begin printing those documents necessary for the punitive damages trial. Our printer was located on a small table just outside the courtroom doors. Now, listen to this shit. Listen to what went on after the verdict, but before they were told that they were going to have to cough up $260 million. This is just after they said that you're liable. So imagine what the conversation would have been like if they would have got nailed for $260 million immediately. This is between being told you have to pay and then being told how much you have to pay. Listen to this shit. I was sitting on a bench directly outside Courtroom D's doorway with our team's legal assistant, Connie Stumpf, facing the courtroom doors. Less than 10 minutes after I relocated to the bench just outside the courtroom, I heard a loud noise. I looked up and saw the double doors of the courtroom swing open. Mr. Shapiro glanced at me while moving quickly out of the courtroom and to his left down the hallway. As he exited the courtroom, he loudly exclaimed, "Fucking ridiculous," and "fucking scumbag family," and continued muttering other similar explicit phrases as he walked down the hallway with Mr. Lessing, the defense's team paralegal, behind him. He repeated these expletives and other similar phrases as he turned the corner to the room utilized by the defense team. Mr. Shapiro's comments were made in the hallway where members of the public and the media gathered throughout the trial. I declare under penalty of perjury that I have reviewed the foregoing declaration and the facts stated in it are true. Yeah, so there's a lawyer who's just lost a case, yelling in the hallway where the public and the media can hear him, "Fucking ridiculous" and "fucking scumbag family." Yeah, to be fair, they'd already been handed $211 million verdict at that point. And to be fair, but still, you shouldn't do that. Yeah, Shapiro missed his vacation. Maybe he can take a vacation in jail and sanctions. Well, I would like the judge to make it so that he can't afford to take a vacation from his earnings in this trial. That would be fun. Yeah, I think he was a little upset he lost. You see, that is just so unprofessional. That is just so uncalled for. But what do we have in Exhibit G? We have another affidavit. This is from Connie Stumpf, who was there with Gabriella Carlson. So we have two people in the same place at the same time corroborating what Shapiro did. I, Connie Stumpf, pursuant to Florida Statute 92.525, declare under penalty of perjury that I make this declaration based upon my personal knowledge of the facts contained herein and state. I am a legal assistant with Anderson Glenn LLP and assisted plaintiff's counsel throughout the Kowalski v. Johns Hopkins All Children's Hospital Inc. trial. On November 9th, shortly after the verdict was read, I exited the courtroom before the court took a recess ahead of the punitive damages trial. My purpose in exiting was to begin printing the documents necessary for the punitive damages trial. Our printer was located on a small table just outside the courtroom doors. I was sitting on a bench next to the law clerk with our office, Gabrielle Carlson, directly outside courtroom D's doorway, facing the courtroom doors. I corroborate everything within Ms. Carlson's declaration being filed contemporaneously, especially the statements made by Mr. Shapiro. Mr. Shapiro's comments were made in the hallway where members of the public and the media gathered throughout the trial. I declare under penalty of perjury that I have reviewed the foregoing declaration and that the facts stated in are true, executed on November 27th, 2023. And that brings our little reading to an end, folks. That brings our little update here. So what we've got to look forward to is November 11th is the deadline for the plaintiffs to submit their response to the motion, their renewed motion for a directed verdict, the motion for a new trial based on legal errors, their motion for a new trial based on inappropriate damages, and their motion for the judge to just tell them what the real numbers should be and reduce the. So the response has to be submitted by closing on the 11th of December. Then at 8:30 a.m. Eastern on the 15th is the motion hearing for these various motions that have been filed. They're going to be discussing 7 or 8 matters that we discussed at the beginning, which I'll be doing my. I'll have to think about what to do. I might have to move my Merry Effing Christmas stream, but we'll see. That's not what we're talking about here today. So that's what's coming up in this trial here. What's coming up for me tomorrow? We're going to be looking at a new case. This is an interesting case in that it was an immigrant he was an illegal immigrant in Florida, 18 years old. He had entered apparently illegally, and he was in a detention facility for a while, and he was released to his relatives in the States pending the decision regarding his immigration status. While he was doing that, he was sitting outside of a building one night. He was approached by an officer who asked him what he was doing. The kid didn't speak a lick of it. Well, he spoke a lick of English. Just absolute minimal yes, no, yes, no. Sort of one of those things like if you go to a new country, you memorize the phrase, where's the bathroom, but you can't understand the response. So basically, the officers were giving him commands, and he was saying he doesn't speak English, and he was just saying yes, yes, no, no, sorry, 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 things like that. It ended up with him being tackled by a couple of officers, struggled for 6 minutes, tased repeatedly, put in handcuffs, and then the first officer on scene dropped dead of a heart attack. The guy was charged with resisting arrest and murder. He was charged with felony murder because the cop dropped dead while he was doing that. But in July, the murder charges were reduced to, I believe, aggravated manslaughter. So that's what we're going to be looking at tomorrow. Whether he should be charged under the circumstances. We'll look at some body camera footage. We'll look at some news articles. Is it appropriate in this case or any other case for someone to be charged with murder or manslaughter because a cop drops dead after an arrest? So we'll talk about that tomorrow. Don't miss that. And then on Thursday, we'll be continuing our review of the closing arguments for the O.J. Simpson case with co-host Chandler Remington. And then Friday, we will be discussing YNW Melly or Alec Murdaugh. I can't decide which one to get to first because there's so much going on in the Murdaugh trial with Becky Hill. The matter has been turned over. Becky Hill is being apparently investigated for a couple of serious wrongdoings to the point where the attorney general who called her my Becky Boo or whatever on the day of the verdict, he has now taken over the investigations into alleged wrongdoings by her and probably her son too. There's so much to go through. So we'll either do YNW Melly updates or Murdaugh on Friday. That's where we are. Carlos Delfino says, I bet you're not explaining this properly. There can't be a case like this. Oh, yes, there can. There is. We'll talk about it tomorrow. And the problem is I can't get a copy of the court documents because the county it's in Florida has some really weird rules that would require me to download a form, fill out the form, submit the original, and do other things like that. So I'm trying to find the documents in another way. But yeah, that's actually what happened. The illustrious Stephen Gosney tipped me off to that case. So kudos to him for pointing out this wild case. So we'll see how it goes. But that's it for tonight, everybody. Thank you for joining me here. We ended up with 701 likes. We got 893 people here still here. I'm sure there's at least 300 or 400 of you that haven't hit that like button. So while we're wrapping this up, do me a big solid favor and reach down there and smash that like button. Hit the subscribe button if you haven't already, because I would love to have you as a subscriber. These are the things we do. We review and comment on motions and trials. Like I said, we're doing the YNW Melly double murder retrial. We're following the Murdaugh trial. Sarah Boone, we were going to do her
phrasing. We
were going to review her trial on the 15th when it was supposed to start, but that's been bumped to at least January. Courtney Clenny it was supposed to be on the 11th, I think. Today? Anyway, it's supposed to be around here. Her and Courtney Clenny were around the same date. Courtney Clenny is still supposed to go later this month. Yeah, so I think one was the 11th and one was the 15th, whatever it was. But Courtney Clenny is still scheduled. It hasn't been bumped back. We'll see how that goes. But these are some of the things we're going to be following as they develop. We also do other things as time comes up. And on the 15th, so far right now, although there is maybe a hearing, I doubt the hearing is going to be brought. It might. I just don't know. But something tells me that it probably won't. But it might be. I don't know. If it is, we'll watch it on a different day, maybe the next day. But the 15th will be a Merry Effing Christmas, drunken, grifty booze-a-thon that we'll all have fun with. Mods, thank you for being here. Let's see how our poll ended up. The like and subscribe and vote poll. How many zeros should have been awarded? Okay, it finished up exactly how it was a little bit earlier. 7% of you said she should have got she should have got 0 zeros. 16% of you said 14 or more zeros. 30% of you said she got the right amount of zeros. And 46% of you said there are not enough zeros to give her. That's the end of the poll. Thank you so much for just taking our daily little like and subscribe poll. And our final comment of the day, Cheeseheads lost on Bourbon Street. Member for have I been doing memberships for 15 months? Dang, Cheesehead lost on Bourbon, OG of the OGest OGs. Oh my, was Becky the arch enemy responsible for the offing of the family conspiracies? At this point, I don't know. She really wants to write a book. All right, mods, thank you so much for being here and devoting your time and your talents. Soon, everybody, in the next couple of weeks, we're going to be having our annual very moddy Christmas where you get to meet the mods. Thank you, everybody, for all of the help, all of the support, and all of you in chat, the Vice Squad chat. If you've been here more than 30 seconds, you are a member of the Vice Squad. So thank you so much for that. Right now, I'm going to see where we can send you next, whilst I thank all of you for your participation in chat. The chat is the greatest chat on the internet. Thank you for respecting each other. Even those of you with differences of opinions, thank you for working them out and being good people about it. That's what it's all about. Have disagreements, but know where the line is and stick to it. You're better than other channels. Act like it. I do appreciate all of you, and the support with the super chats, the monthly chats, the subscriptions, all of that is just icing on the cake. I love having you guys here, and we are going to redirect to there's a place I want to send you, but they don't seem to be streaming. Dang. All right, in that case, we are going to send you to Megan Fox investigating the taking of baby Cyrus. You should get sent over there automatically. If you're not sent over there automatically, there's going to be a little thing at the top, a little blue thing saying, "Hey, everybody, come and check out what's happening over on Megan Fox's channel." And if that doesn't work, you're on your own to go there or go somewhere else. So, all right, everybody. I don't trust you, Jeffo. Well, I don't trust you, Darth Hideous, and I think that's a great way we should be because, good luck getting there. If you don't get there on your own, Darth Hideous, it's all my fault. Everybody, thank you so much. Take care. Tell Megan Fox hi. Tell her Legal Vices sent you. Enjoy the Vices raid. Let's see what she's talking about. I'll pop on over there for a little minute myself as well. Until we meet again tomorrow for this new bizarre case. Take care of yourself. Take care of each other. And whatever you do, whoever you do it with, however good it feels and however many times you're going to do it, just make sure you enjoy those legal vices. Larac saying, peace out.